Friends, we are starting now. Today is 185th Friday group meeting. The topic is an overview on the law of injunction. The speaker is our Friday group member and young promising friend, Mr. K.V. Muthu Kumar, advocate. He is practicing here since long. Since inception he is with us. He is going to address us, Mr. Muthu. Rest of the things.
Geeta will must say about Muthu's CV. We catch this.
A very good evening to all of you. Success is no accident. It is hard work, perseverance, learning, studying, sacrifice, and most of all, love of what you are doing and learning to do. Distinguished guests, esteemed colleagues, and fellow members of the legal community, it is with great pleasure that I stand before you to speak about an exceptional advocate who has made a name for himself in the legal profession. Mr. K.V. Muthu Kumar is a shining example of dedication, knowledge, and professionalism. And it is an honor to recognize his outstanding achievements. With over 14 years of experience, Mr. Muthu Kumar has proven himself to be a reliable and knowledgeable advocate. His educational background speaks volumes about his dedication to the field of law, having earned a Master of Business Law from National Law Schools, Bangalore, and BA LLB from Bangalore Institute of Legal Studies. He is also enrolled with the Karnataka State Bar Council, which attests to his credibility as a legal practitioner. Throughout his career, Mr. Muthu Kumar has demonstrated his versatility by handling cases across different courts and tribunals. He has argued cases before District Court, Magistrate Court, and tribunals in Bangalore, as well as the Honorable High Court of Karnataka and Delhi. He has experience extends to various areas of law, including labor, service, constitution, public interest litigation, cooperative societies, civil procedure, land revenue, and land reforms. What sets Mr. Muthu Kumar apart in his exceptional performance in the Supreme Court of India? He has cleared Advocate on Record exam in 2016 in his first attempt and has since been practicing before the highest court in the land. He has drafted and argued special leave petition, appeals, writ petition, and transferred petition, among others. His impressive track record includes handling cases related to arbitration, company law, labor law, service law, constitution law, public interest, cooperative societies, civil procedure, land reforms, land revenue, land acquisition, taxation, and last but not the least, criminal matters. Mr. Muthu Kumar's dedication to his client and his profession is unparalleled. He is a true asset to the legal community and a role model to the aspiring young lawyers. Thank you.
Thank you, Geeta. So nice of you.
Thank you, Geeta, for this such a wonderful introduction. I don't know whether I'm worthy of such praise or anything, such lavish words, but anyway, I'll try to justify it someday or the other. So, before I begin, I like to thank Sheshu sir for this opportunity, because addressing Friday group, not only addressing Friday group, the only profession or one such profession where the members of the fraternity are called as learned. I don't see many professions or any other work where the members are addressed by the suffix learned. So to address a learned group is a privilege and honor, and I consider this as an honor. And again, once again, thanks sir for this. Now, before I begin the topic of injunction, because the topic of injunction itself is vast and it requires an in-depth talk, and each one, say for example temporary injunction itself requires at least one session. So what I am going to do is just going to do an overview of what injunction is all about. That too in common law. That is, since we are all practitioners in different courts, what normally in courts we face, what are the types of injunctions we are dealing. I'm just going to have a small discussion or small talk about it. The small, that is what do you call, some of the things that we would normally be dealing in every day of our practice. So before I begin, what is the meaning of injunction? Injunction means this: it is an order or a command or a direction by a court to restrain or prevent someone not to do something. Generally, it is understood in a very negative context, wherein the court asks someone not to do something or his agents not to do something. It can also have a positive effect where the court can actually ask someone to do something. Say, for example, it can direct a defendant to do something. That is mandatory injunctions, which I will deal it with later. But generally, an injunction is considered to be a negative or a preventive relief, where the court restrains someone from doing something. That is injunction law. So now when we talk about injunctions, what is the Indian law that governs injunctions? Broadly, Indian law, we refer to Specific Relief Act, where most of our injunction remedies or remedies under injunction are sought under the Specific Relief Act. That is Chapter 7 and Chapter 8, 36 to 42. And also the procedural law would be Order 39, Rule 1 and 2 of CPC. Even Section 9 of Arbitration Act also talks about injunction. And also under criminal law, Section 142 CRPC also talks about injunction, where the executive magistrate can grant an injunction, though it is considered more of a civil remedy, and also since we are more in discussing about civil issues, so it is not I think what you call it is not appropriate to deal with the criminal law right now. So when we talk about injunction, what is the limitation to file a suit for limitation? A limitation to file a suit for injunction. So the limitation under the law Limitation Act is Article 135 and Article 137. Article 137 talks about the suits where no period is prescribed for instituting a suit for limitation, and for mandatory injunction it is Article 135. So next we come to what are the types of injunctions that normally we deal with in courts. One is a temporary, or first what we call it as ad interim temporary injunctions, where the plaintiff feels an imminent or immediate threat from the defendant, so immediately institutes a suit saying that, look, my property or my property that I am in possession is being threatened by the defendant, so please grant me an injunctive relief. So therefore the court, without going into the merits, immediately grants the injunction, sensing that there is imminent danger to the property of the plaintiff. So when then ad interim ex parte injunction is granted, the procedure that is normally adopted is this: the court then immediately sends the copies of the plaint, affidavit and other documents to the defendant, and the defendant once appears, the court has to decide within 30 days as to whether the order of granting ad interim ex parte injunction can be confirmed or not. Now, once the order of injunction is confirmed, then there is an appeal by way of Order 43 Rule 1, where the aggrieved party, either the defendant or if the plaintiff fails to get an order of injunction, he can appeal before the higher court, that is district court or the high court in many cases. So, this is about temporary injunction. Now, what are the parameters to grant a temporary injunction? The court has given down three broad parameters. 1, prima facie case. 2, balance of convenience. And 3, irreparable loss or injury. So what is meant by a prima facie case? A prima facie case would mean that the court, upon looking into the evidence or the evidence led by the parties, will come to a conclusion that, okay, the plaintiff has a prima facie case, therefore the grant of injunction is warranted. Now this second aspect is balance of convenience. Rather, it can be called as balance of inconvenience. The court is looking into the mischief or damage that would be caused if an injunction is not granted. So what is the comparative hardship if injunction is not granted? Based on that, the court grants injunction. So the third one is irreparable loss or injury, which is the main thing according to me, because the court, while granting injunction, has to see if the injunction is not granted, even if compensation is paid. Say for example, I have a property which is 250 years old and it is a heritage structure. The defendant is trying to demolish or destroy or alter the property. So if an injunction is not granted and the property gets demolished, even if you pay me 3 times the value of the property, I am not going to get back what the heritage value that property has. Therefore, the court will go into this aspect as to what is the irreparable loss or injury that has been caused. And there is one judgment of the Supreme Court which actually deals with it, and that is Mrs. Bestseller's judgment, where the Supreme Court says this: even though you have made out a prima facie case, even though there is balance of convenience in your favor, if there is no irreparable loss or injury that is going to be caused, then the refusal of injunction is justified. That is what the Supreme Court has said in this judgment. Now, the next type of injunction is normally perpetual injunctions, which are injunctions where the relief of injunction is granted as a final relief. Say for example, you institute a suit for injunction. Apart from granting a temporary injunction, the court, after it comes to a conclusion, that is when both the parties have led the evidence, arguments have been heard, and the court prima facie feels that there is enough material to grant injunction, the court grants perpetual injunction. Perpetual injunction means this, that the defendant or his henchmen or the agents or anybody associated with the defendants shall not interfere with the property of the plaintiff or the applicant. Now, another interesting thing is this: who can actually seek injunction? Normally, it is the plaintiff who is the dominus latus who can actually seek injunction. But in exceptional cases, the defendant can seek injunction. This has been affirmed by many high courts. In fact, the first one, if I am correct, the first high court to actually lay down such a proposition was the Kerala High Court way back in the year 1957. So the Kerala High Court said that Order 39, Rule 1 and 2 does not prohibit a defendant from asking an injunction. So how can a defendant ask for an injunction? Say for example, in a suit for an easementary right. So suppose there is an order of status quo that has been passed by the court. Now the plaintiff, on the basis of status quo, tries to violate the easementary right of the defendant, then defendant can approach the court for seeking an injunction, and the court can also grant injunction. There are several high courts which have actually said that defendant can also seek injunction. In fact, there is no direct judgment, as far as I know, of the Supreme Court where it has said that defendant can also seek injunction. There is one case of Tamminedi Ramakrishna versus Jayalakshmi, where the Supreme Court thought of deciding the issue. Initially, they issued notice on this aspect as to whether a defendant can seek injunction. Subsequently, after notice, the SLP was dismissed. Therefore, it can be assumed that the Supreme Court also agrees with this proposition that the defendant can also seek an injunction. So the next issue is this. What stage can injunction be sought? Injunctions can be sought at any stage of a trial, appeal, even in the Supreme Court. Now in Supreme Court, since most of us are practicing in Supreme Court, there is a provision to seek injunction. In fact, I have in one case filed an application for grant of injunction and the Supreme Court has allowed it. And if those of you who are more interested can actually go to the Supreme Court website. On the left hand column there is left hand side there is a column called interlocutory applications, where if you search the nomenclature there are two headings. One is interim injunction and grant of injunction. Therefore, even the Supreme Court is empowered to grant injunction in an SLP or in a civil appeal or in any matter pending before it. The next issue would be breach of injunctions. Now, what happens when the court grants injunction and there is a breach of injunction? when the court grants injunction and the defendant breaches an injunction, what is the remedy? The remedy lies under Order 39 Rule 2A, where you can file an application before the court to either seek remedies of attaching the property of the defendant, or the court can pass an order of sending the violator to prison for 3 months, and in exceptional cases can do both, attach the property as well as send the violator to the prison. That is the consequences of breach of injunction. The Supreme Court says that it is not necessary to file a contempt if there is a breach of injunction. The aggrieved party can seek recourse under Order 39 Rule 2A to punish the violator. Now, what happens to a third party if you want to seek an injunction against a third party? Can a court grant injunction against third party? The Supreme Court in a recent judgment has held that injunction cannot be granted against a third party, and if injunction has to be granted, they have to be made as parties. And the judgment is Aqua Borewell Limited versus Swayam Prabha by Justice M.R. Shah and Nagaratna, where they categorically have held that if there are substantive rights that are existing to a third party, without making them parties to the suit, an injunctive remedy cannot be sought. This is what the Supreme Court has recently held. The exceptions to it are again John Doe orders that is under Copyright Act, but it is mostly passed by the High Court, and so far as far as I know, there is no authoritative pronouncement by the Supreme Court on John Doe order. So that can be discussed by someone who is more proficient in copyright law. Then what happens, and what are the circumstances in which an injunction can be refused? An injunction can be refused when the party does not approach the court with clean hands. Say, for example, the party suppresses certain material and approaches the court with falsehood and all sort of baseless things. The court can immediately refuse, or the higher courts can also refuse. In fact, one such incident happened, or one such case where I dealt with was where one of the parties, what that party did was, there was a sale deed by the party in the year 2008 executed in their favor. They filed a suit before a civil court saying that my client is trying to interfere with their peaceful possession and got an injunction. My client had actually filed a suit previously, and his sale deed was much prior, and he had a sale deed in 1990. This was concealed by him, and he got an order of injunction before the trial court. This order was challenged before the High Court. High Court, on noticing this fact, said that the respondent did not approach the court with clean hands. They vacated the injunction granted to him and granted injunction in my favor, and this order was upheld by the Supreme Court. So one of the basic requisites is to approach the court with clean hands. The second issue is this: what other manner, or what are the other ways where injunction can be refused? Section 41 of the Specific Relief Act is very clear. Against a legislative body, injunction cannot be granted. Against against a breach of performance, or against any statutory law, an injunction cannot be granted. So there are many to prevent a breach of nuisance, or say, for example, somebody is being arrested. So I can't go before a court and say that don't arrest him. Grant an injunction not to arrest that person. Such type of injunctions cannot be granted. So this is one aspect where injunctions can be refused. Now the next aspect is this mandatory injunction. When we talk about mandatory injunction is something which the court compels the defendant to do something. Normally, injunction is something where the court restrains from doing something, whereas in a mandatory injunction, the court compels the defendant to do something. Say, for example, there is a contract, and the defendant is not complying with the contract or terms of the contract. So immediately you can file a suit and compel the defendant to fulfill the part of obligation of the contract. That is what is mandatory injunction, and this is an exception to the rule of injunction where the mandatory injunction is granted to do an act. Normally injunction is granted not to do an act, whereas mandatory injunction is granted to do an act, to commit an act, or to fulfill a part of the obligation. This is what mandatory injunction is all about. Now, there's one judgment which I would like to say about the Supreme Court in Kishore Kumar Khaitan and Andar versus Praveen Kumar Singh, 2006, 3 SEC 312. In this case, what happens is, plaintiff files a suit for declaration and injunction, saying that I am a tenant, I am in possession of the property, please declare me as a tenant and restrain the defendant from taking possession of my property. The lower court, that is the district court, grants him injunction. High court also confirms the injunction. The Supreme Court says that firstly, the respondent, that is the plaintiff in that case, did not make out a case for injunction. He did not lay the foundation for grant of an injunction. So, without laying the foundation, he is not entitled to injunction, and therefore this court vacated the order of injunction and put the defendant back in possession. That is what happens in a mandatory injunction, where you can seek restoration of possession. Say, I am dispossessed, and when I seek for restoration of my possession, the court, while granting mandatory injunction, can as well as do it. And the relief of mandatory injunction or a perpetual injunction is only granted towards the end of the suit, whereas temporary injunction is granted at the beginning of the suit or initial stages of the trial, generally. And the injunctive relief can be sought at any stage of the trial, or appeal, or even before the Supreme Court. These are broadly the types of injunctions that we normally deal with in various courts, and we come across this in our day-to-day life. There are some other injunctions, like, say, for example, there are Mareva injunction, anti-pillar orders. These are all injunctions which are normally in commercial suits and commercial transactions. Normal practitioners or regular practitioners of the court, normally we don't do it, so I am not choosing to address those topics at this point of time. So another point about injunction is this: an injunction is an equitable and a discretionary relief. So it is not a statutory relief where once you file an application for injunction, the court will automatically grant it. Court, in its discretion, after going through all the materials, may either grant injunction or refuse injunction, depending upon the discretion. And the discretion again is guided by the parameters, 3 parameters, that is prima facie case, balance of convenience, and irreparable loss of injury. These are broadly the parameters set down by the Supreme Court and followed by many courts from time to time. Now, what happens when for example, when there are many defendants, and if defendant is an injunction is granted against one defendant, can the other defendant operate against the co-defendants or not? The question, to answer that question, normally if an injunction is granted and when the defendants are parties to the suit, despite it not being granted to them, the co-defendants against whom an injunction was not granted cannot say that the court has not granted injunction, therefore I will commit a breach. It equally operates against them. The court, seeing the compelling circumstances, would have granted injunction in favor of against one defendant, whereas if the other defendants also are likely to commit breach, then they also will be liable and they can also be prosecuted under Order 39 Root 2A of CPC. This is broadly about injunctions that we normally deal about in the courts. And what else? There is also one preventive injunction where the court can grant a preventive injunction to abstain an individual from doing something which will potentially harm someone. Say for example, I am going to build a park or something, and I am going to install something which is very hazardous. So in that cases, the court can grant an injunction called as a preventive injunction, where it is likely to cause harm or injury to the others. So that is what is about preventive injunction. And in addition to injunction, the court can also award damages. That is, say when say I have a property and the defendant has encroached or made certain damages to my property. So to prevent further damage, I file an application, the court grants me injunction. Now, what happens to the portion which has already been damaged by the defendant? So the court can, in addition to grant of injunction, can award me damages. Now another aspect is also there, where say there is one part where the court cannot enforce the injunction or cannot grant injunction. That is one, say for example, let me just give an example. Say for example, there is a contract between an employer and an employee. The employer makes certain clauses in his employment agreement saying that this employee shall not work with anyone else post quitting my job. Second, he also has a clause where he says that whatever happened or whatever information that has been received to him from the company shall not be shared with others. So the employee quits and then joins another rival company. So then the employer files a suit for injunction. So the court cannot grant injunction to the first part, because an agreement in restraint of trade is void under section 27 of the Contract Act, whereas this can be enforceable so far as the second part is concerned, where so far as the non-disclosure agreement is concerned, the court can always enforce it. This is under section 42 of the Specific Act, where the courts can enforce a part of the obligation. Whichever is possible, it can enforce. This is about the injunctions normally under the Specific Relief Act and the CPC. So CPC also has section 94 and 95. So 94 and 95 also deals with injunctions, and also, as I said again, section 133 CRPC also deals with injunctions. So section 133 CRPC is when, section 142 CRPC is when there is a breach under section 133 CRPC, where there is a public nuisance committed. Say for example, somebody has blocked a pathway or a river stream. So you can apply before the executive magistrate to get it resolved, and the executive magistrate under section 142 can grant an injunction to the person who is committing such acts and prevent him from doing so. This is one remedy that is available in criminal law. So under at least under the Indian law, injunction has been extended even to a criminal proceeding, a quasi-criminal proceeding before the executive magistrate. So this is all about the injunctions to some and
Thank you very much.
Since it's a last working day of like this, since we have a long weekend, I thought the attendance would be too thin, and I thought of cutting short my lectures, and since I thought that most of them would be planning to go home or planning to have some plans during vacations, I thought I should make it as short as possible, and so prepared in brief. I didn't know that so many people would be attending, including some seniors, which actually made me a bit nervous.
Your injunction works.
Thank you, sir. Thank you. Thanks a lot.
Mr. Muthu Kumar, you do not know how many people are watching.
Yes, sir. Yes, sir.
Ask sir.
So many people.
The eyes that are, the more than the eyes that are present here, sir, the more the eyes that will be watched will be much higher. Sir. So this is about injunctions in general. I am sure that with the presence of large number of seniors and others, they would probably elaborate on various other aspects. I just wanted a brief introduction, and I am sorry that I actually misjudged, saying that there will be very thin attendance to this Friday group today, and I didn't want to take your time and wanted to make it as short as possible. So anyway, once again, I thank all of you, and thank Justice Tappavinavisam, Sheshu sir, for giving me this opportunity, and all of you, and whatever is your feedback, inputs or questions, you can please
Thank you, Muthu. So nicely. See how much glamour you have. You are yourself is a great glamorous boy. In addition to see how much glamour, you explained very simplified everything. I request Rahul Agarwal give a vote of thanks. After this question hours, Srivastava, your question will be last.
First of all, I thank K.V. Muthu Kumar to deliver this speech today, and it was very good. You covered entire all areas of the injunction, whether it's a very wide area, but you covers all the CPC, CRPC, and the arbitration. Even during the lecture, you covered even the Supreme Court has the power for the injunction, and you used to take the SLPs also. You also tell us about the interim injunction, temporary injunction, permanent injunction, what is the perpetual injunction, what are the provisions of injunction at the Supreme Court also, and when the injunction is granted by the court, when the court could refuse the injunction. So overall, the lecture was very good. You tried to cover each and every aspect, so we are very thankful.
Thank you.
Questions, please? Please raise. Please, Jyoti.
Sir, I will ask a very simple question. So, what is the difference between suit for eviction and suit for permanent injunction?
See, suit for eviction is where, say for example, you are a landowner or a landlord, and there is a tenant. So you want to evict the tenant. So the only recourse is to file a suit for eviction. Injunction is to prevent something. So you cannot actually in an eviction, you cannot say that I prevent the tenant from vacating the premises. Rather, the tenant can actually file an application for injunction saying that the landlord or the landowner should not evict me till the proceedings are over. So that is the difference between eviction and injunction. So in an eviction suit, injunction is permissible. But under what circumstances? As I earlier said, injunction is a discretionary relief by the court. So therefore, court, depending upon the facts and circumstances, can either grant or refuse injunction. So there are no hard and fast rules as to whether injunction has to be granted or not.
Yeah. Anyone? Next question, please. Ahmed? Yeah, please. That's over. Question is over. Only one question.
What's the main difference between the perpetual and this mandatory injunction? Main difference.
See, let me just put it in a very simple manner. Now, when you file an injunction suit, normally most of people don't know when they just file a suit for injunction. But when you file a suit for injunction, the relief normally that is sought is under section 41 of the Specific Relief Act, which is 41 of the 38 of the Specific Relief Act. 39 is mandatory. 38, which is perpetual injunction. So, in the sense, an injunction order, that is, if your relief, final relief is injunction, that is grant of injunction, that is perpetual injunction. The word perpetual means forever, continuity. So, therefore, a perpetual injunction means forever. That injunction will be granted permanently. A permanent injunction is called as a perpetual injunction, to put it in a very simple manner. And section 39 of the Specific Relief Act says, talks about mandatory injunction. mandatory injunction is a very difficult or a hard type of injunction to get from the court because it is actually compelling the defendant to do something. Here you are only preventing something. So perpetual is prevention, whereas mandatory is asking someone to perform. Say for example, me and G.Seshagiri Rao sir have entered into a contract, and as per the contractual obligation, G.Seshagiri Rao sir has not performed his part of the contract. So I can file a suit for mandatory injunction and ask the court to compel G.Seshagiri Rao sir to complete or fulfill his part of the contractual obligation. That is mandatory injunction.
What is the stage of the perpetual and this?
Both are final relief.
Final.
Court, after going through the evidence, arguments and everything, at the final stage only can grant such a relief.
I request Mahesh Reddy will ask some question, please. Mahesh Reddy, 1 second. 1 second. I requested Mahesh Reddy.
Well, I think Muthuji has put very succinctly various features, almost all features of the both temporary.
In a very short manner, sir. Just given a beginner's guide, sir.
Yeah, no, in fact, you have touched upon almost the narrow point of this injunctions domain as such. Well, in the light of the recent, provisions made in the infrastructure, large infrastructure projects, these days, there is a very little scope for intervention of the, courts in these contract matters. As a result, what is actually happening is either party, in these contracts, it is becoming extremely difficult, rather invariably difficult to reach out to the courts, rather litigation domain in these areas. How do you see this infrastructure sector? Of course, I am talking not only from this injunctions point of view, but in the overall domain of operation of these contracts in the large infrastructure projects.
I can just answer with one word, sir, one Latin maxim, ibi just ubi remedial, which means that where there is a law, there is a remedy. So whatever be the project, whatever it is, you can always approach the court, sir. A person cannot be prevented from approaching the court. In fact, that is what section 41 talks about, when injunction can be refused. I cannot seek injunction asking a party not to approach a court. I cannot restrain a person from approaching the court. You can never seek an injunction from approaching court. And right to approach your court is a fundamental right, and you can always approach the court, whichever court or tribunal. If there is a statutory law, then under the statute, whatever is the provision, you can approach that court or tribunal or the forum.
With a little bit of suffocation. Anyway, we will discuss.
No, I don't think that there can be any prevention or a prohibition to approach the courts. That is a fundamental right guaranteed to every citizen of this country.
Amen, please. Amen.
I am very happy to have a very good topic here chosen. I am having two queries, just wanted to have a glimpse on those two things. First thing is whether the defendant is also having the power to move an injunction application in the preemptive suit. Second, what about the things which we can go with the consequential injunction? Sometimes we used to file the suit seeking in the way that the things may come change during the pendency of the suit. So we move the application with suit with the relief of consequential injunction, whether it is a suit of a money or for the property. So what the things come in future coming, we used to say in the consequential injunction. Will you able to give a glimpse or a light on that thing?
So to answer your first question, I think I have already answered that during my lecture.
Joined late actually, 15 minutes late.
So there are few judgments. The first one was by the Kerala High Court, way back in 1957. That is B.F. Varghese versus Joseph Thomas, where first time the Kerala High Court laid down the law saying that even a defendant can seek injunction. This has been followed by subsequent in various high courts. One, I think there is a judgment of Patna High Court, judgment of Calcutta High Court, where all the high courts have said that a defendant can seek injunction. So this, so far as the law is concerned, it is probably well settled that even a defendant can seek. And Supreme Court had, I think, once had an occasion to deal with this, but the Supreme Court unfortunately dismissed the matter Probably we can take it that the Supreme Court has affirmed the view of the various high courts, saying that even a defendant can seek injunction. To answer your second query, consequential relief. Consequential relief is normally granted towards the end of the suit. Now, in between, say what happens is there is a breach, or there is some loss or imminent danger, threat, dispossession, whatever it is. So, when there is certain violation or an apprehension, then immediately either party who is aggrieved can move an application. As I earlier said, there are three parameters that the court has to look into: prima facie case, balance of convenience, and irreparable loss of injury. So under the third category, irreparable loss of injury, the irreparable loss or injury, the court can then on that basis grant you an injunction, or probably balance of convenience, where I have said that it is more of balance of inconvenience, where you will be put into inconvenience, and the substantive mischief or harm that is caused to the plaintiff or the defendant cannot be compared, cannot be equated, and the other party will not be prejudiced or put into hardship. In that cases, injunction can be granted. As I said, at any stage, before any court.
So nice.
You further, you have to pay T bill. Second question, you have to pay chai bill.
Oh, yeah, sure. Sir, what is the difference in claiming adverse possession and claiming permanent injunction?
The adverse possession is different. Adverse possession is when you are in long and continuous possession for more than 12 years, you claim adverse possession. When the possession becomes adverse to you. Injunction is different, where, as I said, in a very simple manner, injunction is to restrain someone from doing something. As simple as that. So, it is one very good question also, because say when you are filing a suit or you filed a suit for adverse possession, you can normally file and also seek relief of injunction, because you can say that I am in possession for such a long time, the defendant is trying to dispossess me, please grant me injunction. In fact, there is one judgment of 2008, Anatula Sudhakar judgment of 2008 by Supreme Court, where they say that when the title of the plaintiff is in cloud or the title is disputed by the defendant, then a suit for bare injunction is not maintainable, and he has to mandatorily seek the relief of possession. So without possession, a relief of injunction cannot be granted by any court. This is the law that has been held by Supreme Court.